Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly. For those of you who are here early, thank you for waiting patiently. While waiting, we'd like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled An Introduction to Strata Management Bylaws. My name is Daphne Retwal. I'm a Senior Associate with Ma Wing Kwai & Associates, and I'll be your moderator for today. Before we start today's talk, let me introduce the firm and what we do. Ma Wing Kwai & Associates is a mid-sized law firm that was founded in 1985 by Dato' Ma Wing Kwai. Our able team today comprises 32 lawyers and a support team of 34. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, a dedicated employment industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolutions team. Today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Today, we have two speakers, John Chan and Jasmine Wee. John is a partner in our dispute resolution and employment and industrial relations departments. He obtained his Bachelor of Laws from University Kebangsaan Malaysia and was admitted to the Malaysian Bar in 2014. John is actively involved in the Bar Council Sports Committee, and his areas of practice include employment law, unfair and constructive dismissal disputes, strata management disputes, and contractual and commercial disputes. Our second speaker, Jasmine, is an associate in our dispute resolution, corporate, individuals and families, and employment and industrial relations departments. She obtained her Bachelor of Laws from the University of London. Her areas of practice include the laws on employment, corporate litigation, strata, adoption, citizenship, and immigration. Jasmine regularly provides advice to clients on various strata management tribunal claims. Without delay, I'll invite Jasmine to speak first. The areas that she will cover would be key areas covered by laws, duties, rights, and liabilities under the bylaws. And John, who will be our second speaker, will be speaking on requirements to pass additional bylaws and challenging the validity of non-compliant bylaws. We will then conclude with a Q&A session. So if you have any questions, please don't forget to type it up in the Q&A chat box. So without further ado, I will hand over the floor to Jasmine. Over to you, Jasmine.
Thank you, Daphne. So good afternoon, everyone. Once again, I'd just like to thank everyone for taking time out of your day to join us on our talk today. So as Daphne said, I will be covering the first 2 points and John will be covering the last 2 talk points. But before I start, I just want to remind everyone that this is merely an introduction to Strata bylaws, the provisions of the Strata bylaws. So we are not going to go too deep into it today. So without further ado, we'll start with key areas covered by the bylaws. So starting off the definition of bylaws, you can find this definition in the Strata Management Act 2013 under Section 2, which reads as bylaws which are in operation in respect of the building or land intended for subdivision into parcels or the subdivided building or land, and the common property as prescribed by the regulations made under Section 50, 150 for regulating the control, management, administration, use and enjoyment of the building or land intended for subdivision into parcels or the subdivided building or land, and the common property or provided for in any additional bylaws made under sections 32, 70, or 71 of the SMA. So bylaws that gave birth basically to the Strata Management Regulations can be found in section 150 of the SMA. And this is a copy of the front page of the SMA, as you can see. So if you look up the SMA, you'll be able to see all sorts of bylaws that are usable for your strata development. And also just to note, strata bylaws came into force on June 2015, I believe. And previously, they used to be known as house rules. Today, you can see in strata developments that both of them do exist. They coexist side by side, and they are meant to function in tandem with one another, so long as they don't contradict statutory bylaws. Additional bylaws are something that is not already included in the statutory bylaws, and you can make additional bylaws by passing a special resolution. And you can pass a special resolution for bylaws that entail things like behavior, architecture, and landscaping guidelines to be observed by all parcel owners, and imposition of a fine that does not exceed 200 ringgit against any parcel owner, occupant, or invitee who is in breach of any of the bylaws, safety and security measures, details of any common property of which the use is restricted, keeping of pets, parking, floor coverings, refuse management, which is basically trash management. And now we move on to the binding effect of bylaws. So under section 32 of the SMA 2013, bylaws having effect in relation to every building or land intended for subdivision into parcels and common property will bind developer and purchasers during the developer's management period. It will also bind joint management bodies which come after the developer and all parcel owners constituting the JMB, as you can see in the third schedule of the SMA. And then under section 70 of the SMA, bylaws having effect in relation to strata development will also bind management corporations, otherwise known as MCs or sub-MCs, as the case may be, and it will bind all proprietors constituting the MC or sub-MC. This can also be seen in the third schedule of the SMR. So if you look at the SMR, you will see that there are about 30 bylaws in total, and they are separated into 8 parts. So what these 8 parts cover is basically functions of the management corporation. They function to benefit both a management body and also a proprietor. So if you're a management corporation, it will teach you basically how to properly manage and enforce the rules that are there against any proprietors or any person that steps foot on the premises, basically. And it also talks about property for common benefit, and it encourages condominium living, basically. It also talks about provisions of amenities or services that are provided by the strata development. And it also teaches MCs, JMB, developers how to deal with defaulters, which are people who do not pay their sinking fund, contribute to their sinking fund, and do not pay any charges that have been lawfully imposed by the MC. So it also confers powers upon the MC to impose a fine, as earlier mentioned, which does not exceed 200 ringgit. So the value of this fine is meant to be decided at the individual AGMs of the strata development. It also provides general duties of a proprietor. It covers behavior and things like that, which we will get into later on. And also prohibitions for a proprietor, prohibitions of nuisance. It talks about appearance, facade, and color of the exterior of the parcel and how you should go about these things if you intend on carrying out renovation or even fixing out any fixtures in the external part of your parcel. And of course, it covers storage, inflammable explosive materials, pest control, keeping of animals, which usually is a common problem that we see, drying of laundry, teaches you how to comply with the bylaws, identification in the form of persons who come onto the strata development, And the security will ask you for your identification card, or usually they'll ask you to sign a guest book, things like that. Firefighting installation equipment, notices and signs, prohibition of obstruction, gardens, lawns, potted plants, how to maintain them, how to keep them. Talks about provisions of encroachment on common property and other parcels, furniture, fixtures, things, children playing on common property, vehicles, solid waste disposal, renovation works and repairs, restriction in renovation works, the power of the MC to take proceedings as an agent of a neglected parcel or any defects to proprietors' parcels, and also other prohibitions, which include hacking, drilling, punching of nails, screws into the walls, installation of any television or radio antennas. Take, for example, installation of television and radio antennas. When you put these things, they're quite large and sometimes they can be quite unsightly. So this relates back to affecting the facade, the exterior of a person's parcel. We then move on to the duties, rights, and liabilities under bylaws. And the duties, rights, and liabilities that we're talking about is going to cover in all aspects for developers, JMBs, MCs, and also the proprietors themselves. So the SMR itself specifically only provides basically MCs, but Section 1 of the SMR does also specifically state that bylaws, they will bind and they will apply to proprietors, developers, JMBs, MCs, and in some instances, subsidiary management corporations. Of course, to the parcel, the purchasers, parcel owners, proprietors, chargees, assignees, lessees, tenants, occupiers, and invitees, basically anyone who steps foot on the strata developed property. So these, right now, I'm talking about the shared duties of a developer, JMB, and MC. As I mentioned earlier, in the SMR itself, it specifically, the large portion that it covers, it provides very specific details on how an MC should function basically under a bylaw. But if you look at the SMA itself, duties of a developer and the JMB, so there are many guidelines for developers and JMBs to follow and MCs as well. So one of the shared responsibilities, of course, is to enforce the bylaws at any given time, and all bylaws and additional bylaws as well will bind the developer, the JMB, the MC, and the user of the parcel as if the bylaws have been signed or sealed by each of the persons or bodies named, and they contain mutual covenants to observe, comply, and perform all provisions of the bylaws or additional bylaws. And another developers, JMBs, and MCs have is the duty to keep record of additional bylaws in force from time to time, and they must supply parcel owners with a copy, and they have to make additional bylaws available for inspection. So what this means basically is developers themselves, when they come into incorporation, they follow statutory bylaws that are already provided under the third schedule of the SMR. And so one of the developers' duties is, of course, to hand over to a JMB. If during their time they have made any additional bylaws, then they have to keep record of it. Otherwise, the coming JMB, they're not going to know. Same with the JMB. If they make any additional bylaws during their time in corporation, they will also have to hand it off to the MC. And as for supplying parcel owners with a copy, there is a fee that you can charge parcel owners, and I believe that to be 50 ringgit. And they have to put in a request, however you wish for them to put in the request. Usually it's written request. So if they do put in a request, you have to provide it to them. And if they ask for it, you have to make it available for inspection. And this power is conferred to them under sections 32 sub 5 and 70 sub 4 for the SMA. Another shared duty of the JMB and the MC only is that they have to make additional bylaws at the first AGM. So when they convene the first AGM, one of the agendas has to be to make additional bylaws. For the developer, they do not have to make additional bylaws, but they can if they want to. And making additional bylaws for the proper maintenance and management of the buildings or lands intended for subdivision into parcels and common property. Let's say you are a management body and you feel that the already existing statutory bylaws are not enough because every development is different. You have different needs and you have different types of persons living on your development. You can feel free to make additional bylaws so long as they do not contravene or the already existing statutory bylaws. And of course, developers, JMBs, and MCs all share a duty to do all things reasonably necessary for the performance of its duties under the SMA and for the enforcement of the bylaws. And this is conferred to them under sections 21 sub 2 sub H and 59 sub 2 of the SMA. So as I mentioned earlier, upon dissolution of the developer or the JMB, they have to hand over additional bylaws to either the JMB or the MC, depending on which stage they're in. Now, for the specific duties of the MC under the bylaw. So these, again, you can find in the SMR itself. This includes, where applicable, they have to establish and maintain suitable lawns and gardens on common property. Wherever applicable as well, they have to manage, maintain, and secure suitable operators for any common utilities, amenities, and services in the common property. So these would be things like swimming pools, saunas, gyms, and so on and so forth. Upon request, again, they have to furnish proprietors copies of all policies of insurance effected under the SMR or against other risks as directed by proprietors by a special resolution, together with copies of receipts of the last premiums paid in respect of said policies. They also have to set up, manage, and maintain proper procurement procedures and tender process in a fair and transparent manner for all purchases, acquisitions, or awards of contracts in connection with the management and the maintenance of the common property. So just to let you know, common property would be things that are shared with other users. So it's not just used by you. So it would be things like car parks, or let's say there's a little garden on top of your condo, your apartment, and the lobby as well is also a shared area, and lifts, things like these are common things. So they also have to set up, manage, maintain a good credit control system in the collection of maintenance charges and contribution to the sinking fund and other lawfully imposed charges, administer and enforce the bylaws as well as the additional bylaws. Without delay, the MC has to enter into the strata role any change or dealing notified to it by any proprietor. So this would include things like if you sell off your property, or if you have a tenant, licensee, leasee, things like that, you have to inform the MC, and when you do, the MC has to take quick action. As an agent of the proprietor, the MC, when it comes to a neglected parcel, they have to take any such action and proceedings that are necessary to have this neglected parcel rectified. So some of you may know, sometimes you may come across proprietors where their house is in a state of disarray, and on the exterior especially, it looks dilapidated and it really does not match the surrounding exterior of the strata development. So you may issue a notice, you issue 2 notices, and there must be a 14-day period in between of these 2 notices, and sometimes the proprietor may not respond or refuse or neglect to do whatever is necessary. So you can take it upon yourself as an agent of the proprietor to fix it for them, and after you fix it, you can recover the cost and expense of such action and proceedings from the proprietor of the parcel in that condition as a debt that is due and owing to the management corporation. So this power is conferred to MCs under Section 30 of the SMR. Now, coming to duties of proprietors, you of course have a say in the way you want your strata development to be run. You're living there and basically you have a right. But in order for the management corporation to continue maintaining the strata development and keeping up in a good state, you have to pay your MC charges and you have to contribute to your sinking fund, because this is what will be used to maintain for the upkeep of the property, and any other charges that the MC may impose. So these will include things like special service charges, which will vary from development to development. As a proprietor, you must also permit the MC at reasonable times, and of course the MC must also give you reasonable notice. And at reasonable times, you have to permit them to enter your parcel for the purposes of investigating any leakages, inflow leakages, or building defects, maintaining or upgrading the pipes, wires, cables, and ducts. And usually they will only do so if these things are being used for the enjoyment of other parcels or they are part of the common property. And they will also have to maintain or upgrade, and this is all part of maintaining and upgrading common property and executing any work for the performance of the MC's duties under the SMR itself, and also the SMA. Proprietors also have to carry out all the work that is ordered by any competent authority in respect of their parcel, other than the work that is for the benefit of the development. So this usually comes about when basically local authorities, when they come up with any sort of new rules or regulations that the proprietors are in the area are meant to follow, then no choice, I have to carry it out. So you also have to repair and maintain your parcel, and especially on the outside of your parcel, you have to keep it clean. And these exterior surfaces will include things like window panes. So for window panes, certain people, certain proprietors, they live in very high-rise buildings, and it may be dangerous for you to get out there and clean your window panes. So certain developments do specifically state that the outer area of the window panes, they are going to be cleaned by the management themselves. So unless specifically stated, you have the duty as a proprietor to keep clean your exterior surfaces. You are also not to use or permit use of your parcel in a manner that causes nuisance or danger to others, or that is contrary to the terms of use of the parcel that is shown in the plan and approved by the relevant authorities. Of course, these will include things like don't do illegal things, don't have an illegal drug den or gambling den. Okay. Proprietors also have to notify the MC of any change in proprietorship of their parcel or any dealings, charges, leases, or creation of any interest for the purposes of entry into the strata roll, as I mentioned earlier. Proprietors, if you are using common property, then you must do so in a manner that is not going to interfere unreasonably with the use and enjoyment of other proprietors. So ensure that your parcel is also not used for any purposes, illegal or otherwise, which may be injurious to the reputation of the strata development. Not to use substances that give rise to smoke, fumes, obnoxious smells, and litter in the common property. So when I say substances that give rise to all these things, it be things like certain strata developments, as you notice, they don't allow durians in the lift. And also there's no smoking, and fuel especially gives off a very strong smell. And littering in the common property, of course, is always a no. And next one would be not to cause a nuisance. And when I say nuisance, what I mean is using foul language or perhaps dressing in a way that could embarrass others. So this, you can see certain strata developments, they put up signs, especially near swimming pools, where they say proper swimming attire must be used. Or one I rarely ever see, but telling people to dress decently when they're in strata development, and not to change the appearance, color code, and facade to any of the exterior parts of your parcel without prior written approval of the management corporation, and when necessary, the approval of the appropriate authority. So this is a very common one that we see that people often argue about. And this is especially if you have, say, exteriors like lanais or balconies, terraces, and things like that. Sometimes people want to wall up the balconies. And from the outside of the condo itself, you can see that your unit would be the odd one out if you're the only one that has walled up your balcony. So of course, these things are not allowed, and it's in order to maintain uniformity within the strata development. And of course, self-explanatory, do not store inflammable or explosive materials that could blow up your strata development. Control pests. This also is another very common thing that people generally argue about. And in controlling pests, sometimes people put up nettings. So specifically in the SMR itself, it does provide that if you're going to put up such netting, sometimes it can be quite unsightly. So you will require the approval of your management body, your MC, your JMB, or whosoever is involved, to see whether or not you can put up these traps. And keeping of animals, that's also another really common one. It has to be in accordance with rules and regulations that are set by local authorities. So for this one, it is common because a lot of people have dogs and cats. So smaller animals like hamsters, fish, those don't really cause much of a nuisance anyway. But dogs and cats, they bark and they meow. So for dogs, for example, DBKL itself, it has a rule that if you are living in a high-rise property, only certain small breeds of dogs can be kept in high-rise properties. So the SMR itself does provide that so long as your animal doesn't cause a nuisance, then it's fine, you can keep it. But of course, it cannot be in contravention of your local authority. So depending on what state you live in, you may want to double check and see whether or not you are able to keep your beloved pet in your condo. Hanging of laundry is also another common one in the balcony. Sometimes you see people have very large or very unsightly kind of clothes hanging contraptions. And this also may cause a problem for proprietors if it looks unsightly, basically. So you may also have to obtain written approval from your management body to ensure that you are able to put up these fixtures. Of course, duties of proprietor, the most important one, you have to comply with the bylaws, and you cannot have anything that encroaches on common property. So an example of this that I have seen is, let's say someone wants to knock down a wall, they obtain the proper approvals, but let's say they want to put up sauna. But part of this sauna, the corner of it, then encroaches into, let's say, the swimming pool area. But the sauna is only used for your own personal use. So of course, that's not allowed. Rights, coming to rights under the bylaws, and these are the rights of a developer, JMB, and MC. If a proprietor is found to be non-compliant with the bylaws or additional bylaws, then the developer, the JMB, and the MC can apply to a court of competent jurisdiction or the Strata Management Tribunal for an order to enforce the performance or restrain the breach of any bylaw from any person that is bound to comply with the bylaws. and this power is awarded to them under sections 32 sub 7 sub A and 70 sub 4 of the SMA. They can also apply to the court or to a court of competent jurisdiction or the tribunal for an order to recover any damages for any loss or injury to any person or property that arises out of the breach of any bylaws from any person that is bound to comply with the bylaws. Developers, JMBs, and MCs also have to take the necessary action to have the condition of a neglected parcel rectified. If the proprietor has neglected or refused within a reasonable time of 2 written notifications of these 14 days in between to urging him to take action. And once you've done so, you can recover the cost and expense because it is a debt that is owed to you. So for proprietors, under the bylaws, you have a right also to apply to a court of competent jurisdiction or apply to the tribunal for an order to enforce the performance of or restrain the breach of any bylaw from any person that is bound to comply with bylaws. And also you can apply to the court of competent jurisdiction or the tribunal for an order to recover any damages for any loss or injury to any person or property arising out of the breach of any bylaws from any person that is bound to comply with the bylaws. So it works both ways. Just as the MC has a right, if your parcel is in a state of disarray and it is basically disturbing other users in the strata development, the MC, let's say, as an agent of a neglected parcel, they can fix it for you. Just as a proprietor, if let's say there is interflow leakage in your house or whatever sort of defect that ails you, can go to the MC, ask them to fix it, and if they don't, you can fix it yourself and later claim it back from them as a debt that is owed to you. This, as I was saying just now, the developer, JMB, and MC, you have a right as a proprietor to have an agent for a neglected parcel. Liabilities under the bylaws. So as far as liabilities go, as I mentioned a couple of times before this, if anybody that is in breach of bylaws, especially proprietors, a management body can impose a fine that does not exceed 200 ringgit. It may be lower also, depending on what you decide at your general meetings when any proprietor that is not found not to be in compliance with the bylaws. Or a proprietor can also be asked to leave the common property due to non-compliance of the bylaws. And you can find this under section 16 sub 2 of the SMR. So a proprietor, it is important to keep note that you are not absolved from any liability which may be incurred or suffered as a result of any failure on your own part to observe and comply with any such bylaws. You can find this in section 16 sub 5. I think we are on the third top point, and I hope that was insightful for you, and I'll pass it over to my fellow speaker, John.
Thank you, Jasmine, and also thank you to Daphne earlier for the introduction. Good afternoon, everyone. I will continue with the third subtopic of today, requirements to pass additional bylaws. So the requirements under the legal provisions are pretty straightforward in terms of how you are to make, how a developer, JMB, MC is supposed to make the additional bylaws. Firstly, during the developer's management period, the developer, like my colleague Jasmine said earlier, may make additional bylaws during its developer's management period, but it has to be approved by the COB. Because at the time there are no general meetings yet, any additional bylaws that the developer wants to make has to be approved by the Commissioner of Buildings. Secondly, when the JMB and MC comes in, any additional bylaws has to be passed by a special resolution. And a special resolution means that it has to be at least 21 days notice for that general meeting to be given to all parcel owners. The notice must specify the proposed special resolution, and at the general meeting itself, it has to be passed by a majority of not less than 3/4 of the votes cast, either by hand or by poll. Now, what happens after the general meeting? After the general meeting, the additional bylaw or bylaws passed at the general meeting has to be certified as a true copy under the seal of the developer, the JMB, or the MC, as the case may be. Once that is done, that certified true copy must be filed with the COB. So if it's by the developer during its management period, once it receives the approval by the COB, within 40 days, it has to apply its seal and then file it with the COB within 14 days. For the JMB, it will be 14 days after the passing of that special resolution. And for the MC, somehow it is 30 days after the passing of the special resolution. After that, all parties during their respective management periods will have to keep a record of all additional bylaws in force from time to time, as was explained earlier already. Now, other considerations or other requirements under the Act. Firstly, that the additional bylaws shall not be inconsistent with existing statutory bylaws. or the provisions of the SMA, the Parent Act. It shall also not prohibit or restrict the transfer, lease, charge, or any other dealing with any parcel, and the additional bylaw shall also not destroy or modify any easement. However, it's worth noting that this prohibition does not appear under the JMB management period. This is only for the MC management period. Now we go straight into the next subtopic, which is how would you want to challenge an additional bylaw, which in your opinion is non-compliant. First, this is not provided under the Act, but this is for the developer's additional bylaw. Because, in my opinion, because the developer needs the approval of the COB for any additional bylaw it makes, then technically you as a parcel owner have a right to write to the COB to complain or to raise any issues regarding that additional bylaw proposed by the developer. Now, after that, during the JMB and MC period, you have a right to put in a requisition to include a motion in a general meeting. So if you want to challenge an existing additional bylaw, or if you want to propose to amend or revoke an additional bylaw, you can do so by putting this requisition in, and it will be included in the next general meeting for discussion and for voting. Even better, if you have a quarter of the share units, or you are made up of proprietors with at least a quarter of the share units, then your requisition for a motion can be fast-tracked into a requisition for an EGM. The law requires that in this requisition, under number 3, you must state the objective of the EGM that you are requesting for. And once that requisition goes in, the JMB or MC must call the EGM within 6 weeks. So it still falls within the special resolution requirement of 21 days, which is 3 weeks. Next is, of course, the filing a tribunal claim. Now, if you look at the fourth schedule of the SMA, under paragraph 8, you will see that the tribunal's jurisdiction includes to hear a claim for an order to revoke amendment of bylaws, having regard to the interests of all parcel owners or proprietors. And if you look at part 2 of the fourth schedule, under the orders that the tribunal can make, the tribunal can order the rectification, setting aside or variation of an additional bylaw, wholly or in part. It can also make any order of which it has the jurisdiction to make, which we saw earlier, which is the revocation, and such ancillary or consequential orders as necessary. Who would be entitled to file a tribunal claim? In section 107 of the SMA, there's quite a long list, which includes the developer, the JMB, and the MC, but for purposes of the topic today, it will be the purchasers and parcel owners. And what section 107 also provides is any other interested person with leave of the tribunal. In this case, any interested person or affected by bylaws or additional bylaws would be chargees, assignees, lessees, tenants, and occupiers of a parcel. And if you look at bylaw, I'm not sure whether 1 or 2, it also includes family members of the parcel owner. So all this, I would say, would come under interested persons that can file a claim to challenge additional bylaws, of course, with leave of the tribunal. So outside of the tribunal, you can, of course, file a civil suit in the civil courts. You can file either a writ or an OS. So a writ will usually involve dispute of facts, with or without dispute of law. So an example would be there's a dispute of whether you as a parcel owner actually obstructed the common property corridor, for example. So there's a dispute of whether you were the one that obstructed the corridor, which gave rise to a certain fine under the additional bylaw. So the court will have to look at that dispute of fact, calling of witnesses during trial and all that. But if the obstruction is not disputed, then you can file an OS and the court can go straight into the dispute of law. So for example, obstruction is there, but whether it's a breach of the bylaw or whether it's a breach of an additional bylaw, that would come under dispute of law. And an OS is usually faster because it does not involve trial. Then we come to the usual or typical grounds for challenging additional bylaws. This list is not exhaustive, it's just examples. Firstly, the ground can be that the additional bylaw passed is inconsistent with existing bylaws. You will have to show why it's inconsistent. Branching out of that, you can also show that if it's inconsistent with the provisions of the SMA or the regulations, or in some cases, it may also be inconsistent with existing additional bylaws, which creates a state of confusion. So you can file a claim to vary or even seek clarification or amendment or a change of both or a merger of both into a clearer additional bylaw. As we saw in the jurisdiction and power to make orders by the tribunal, the ground would be that the revocation, rectification, setting aside or variation would be in the interest of all parcel owners of that strata development. Then coming into more general grounds would be that the additional bylaws may be unlawful, not under the SMA, but maybe under any other legislation out there. It may be impractical, unfair, unreasonable, etc. And lastly, a technical objection would be that the passing of the additional bylaw did not meet the statutory procedures or requirements. For example, the 21 days notice. So that would be the end of the 4 subtopics. We have prepared 2 case studies just to quickly set out 2 cases for you. Firstly is the now quite landmark case of Inap Salil and Verve Suites Mont Kiara. So in this case, the MC passed what they call a house rule, but in essence, it's an additional bylaw. And they call it House Rule 3.0, House Rule 3, with regards to the prohibition of short-term. And this is the exact wording of the House Rule number 3, which we've reproduced here. And you can see under second paragraph, the use of any unit for short-term rentals is prohibited. And we go to Roman 1, any stay for which a booking was made through services, applications, websites, etc., such as Airbnb, Booking.com, Agoda.com, which we are definitely familiar with. And there's also Romans 2 and Romans 3. But the following provision of this house rule also says that any breach of the above shall attract a penalty of 200 ringgit for each day. And the MC can also deactivate your access card and bar the unit from booking any of the common facilities. And it also extends this house rule or the penalty if it is done by the tenant of the parcel owner. So what happened? The MC started issuing fines to errant parcel owners who continued with their Airbnb activities. And towards a certain point, it decided to file a suit in the High Court. So the MC filed a suit in the High Court to enforce this house rule number 3 on majority or most of these non-compliant parcel owners. So at the High Court was held in favor of the MC, saying that the House Rule number 3 is valid, is lawful. Similarly, on appeal, the Court of Appeal held the same. And so it finally went to the Federal Court for determination. And so we have also provided a summary of the Federal Court's decision. In general, the Federal Court decided that the SMA is without doubt a social legislation. It was passed to facilitate the affairs of strata living for the good of the community or owners of the strata title. Being social in nature, the provisions of the SMA 2013, which safeguard community interests, ought to receive a liberal interpretation and not a restricted or rigid one. Accordingly, where 2 different interpretations are possible, it is the one which favors the interests of the community over the interests of the individual that is to be preferred. Now, the context of this will come in the next slide. The Federal Court held that even though the strata building under the master title and strata title was under the category of building and express condition of commercial building, the Federal Court still held that the MC may pass house rules / additional bylaws to prohibit the parcel owners from commercial usage, in this case, short-term rentals. The bylaws are justifiable on the basis that they exist for the good of the community. And in the present appeal, so even if the state authority, the land office, permits the use of the land for commercial purposes under the National Land Code, such use and legal provision is still subject to Section 70 of the SMA, which is the provision that allows the making of additional bylaws. Then the second issue that the Federal Court had to decide was whether House Rule 3 was in violation of Section 75A. And 5A states, no additional bylaw shall be capable of operating to prohibit the transfer, lease, or charge of, or any other dealing with any parcel of the strata development, which we saw earlier. So the court had to decide this. And the court held that there was no violation because the short-term rental arrangements are nothing more than mere licenses, like hotels, and therefore do not amount to dealings in law, which means that additional bylaw can be made to prohibit these Airbnb arrangements. So in deciding this, the court went into very detail into examining many local and foreign case laws. And also it looked at the Airbnb and all these short-term rental agreements between the host and the guests, which was all online, and decided that these short-term rental arrangements are nothing more than licenses, which is what hotels do, and do not amount to dealings in law and definitely do not amount to leases. In the second case, it's the case of Lai King Lung and Anjung Hijau MC. The facts are quite simple. It's between a proprietor against the MC. And here the proprietor's unit had an air conditioning compressor on its balcony, which was visible from the outside. And this was prohibited by the house rules. So what happened after that? The MC had forcibly entered into the proprietor's unit to remove that compressor. And after that, the proprietor sued the MC for trespass, theft, and damages. So in the MC's defense, the MC said that the house rules had already prohibited the placement of the AC compressor on the external of the unit, which was the balcony, and that the house rules also authorized the actions in forcibly entering the proprietor's unit. And in turn, the proprietor's position was that the house rules was ultra-virus. The provisions of the STA, the Strata Management Act, which was enforced at that time because this is a case before the SMA came into force. And at the end, the High Court allowed the proprietor's claim. So the MC didn't win. They allowed the proprietor's claim and decided that at that time, the house rules was not issued by the MC, but was previously by the developer. And this was clearly in violation of Section 44 of the STA to make additional bylaws. And therefore, the house rules with regard to the possible entry and the prohibition of placement of the aircon compressor on the balcony was ultra-virus, was illegal. The court further suggested as follows, that the MC take immediate steps by way of special resolution to adopt the house rules as additional bylaws, and thereafter the MC would be in a position to issue house rules in respect of matters arising out of these bylaws. With regard to the house rules, the court also held as follows. If the MC was required for every rule to be laid down and made by way of bylaws, this would cause practical problems which would disrupt harmonious condominium living. Only those rules that are not likely to be altered from time to time should be made as bylaw. And the court gave some examples. For example, the timing of the usage of the sports recreational facilities or the restaurant. All these can be implemented through the use of house rules only. So while house rules are permissible, they must follow and or clarify or particularize the bylaws passed by special resolution. So one thing to note between case 2 and the earlier case is, in this case, the issue was whether the house rules here amounted to additional bylaws. But in the earlier case, in Verve Suites, there was no issue of whether the house rule number 3 was an additional bylaw because it was passed at a general meeting and it obtained a special resolution of a 3/4 majority. And with that, I would end my presentation for now. Over to you, Daphne.
Thank you, Jasmine and John, for your insights on strata management bylaws. We know that there are a few questions from the floor, so we'll be taking the questions from the Q&A box. The first question is, a subsale owner obligated to comply with the bylaws of the development? I think, Jasmine, maybe you can take this.
Yes, the bylaws are applicable. As long as you are going to be residing there, or you're a guest or proprietor, whoever steps foot on the premises itself, you are obligated to comply with the bylaws, as was mentioned earlier in the talk, where under paragraph 1 of the 3rd schedule of the SMR, it reads, the bylaws as set out in the 3rd schedule and any additional bylaws made under the SMA shall bind the developer, the JMB, the MC, the sub-MC, as the case may be, the purchaser, parcel owners, proprietors, any chargee or assignee, leasee, tenant, or occupier of a parcel to the same extent as if the bylaws or additional bylaws have been signed or sealed by each of the persons or bodies mentioned above, and contain mutual covenants to observe and comply to perform all provisions of the bylaws or additional bylaws.
Thank you, Jasmine. The next question. DBKL has come up with regulations against divisions in apartment to create more room. Is this the responsibility of the management corporation to check and to enforce the regulation? The management in this spectator said the management apparently said that their responsibility is on common areas and anything within the apartment is not their responsibility. John?
Thank you, Daphne. So to answer this question, yes, it is right that the general principle is that the bylaws and the SMA in general regulate the maintenance and management of common property only. But as we have seen in the case of Inap Salil earlier, it looks like the MC may have a right to make additional bylaws to prohibit this in the interest of the strata community as a whole. But coming back to your question, it wouldn't be the MC's responsibility to check and enforce on behalf of DBKL. But if it wants to support or collaborate with this regulation by DBKL to enforce on its own, then looking at Inap Salil, it may have a right to do so. Thank you.
Thank you, John. Next, can a JMB pass a resolution at a JMC meeting for the JMC's common areas security and cleanliness to maintain a part of a unit's internal parcel. I understand this to be part of a private parcel, which is not a common property. Is this legal? Jasmine, maybe you can take this.
No, it's very unlikely that can be done because the maintenance and sinking fund accounts, they comprise of maintenance charges and contribution to the sinking fund that has been paid by parcel owners and proprietors that are to be used for the management and maintenance of common property only. So the funds that have been collected by the collective body of proprietors cannot be used for a singular private parcel because usage of this fund for any purposes outside the provided for purposes under what is statutorily provided for could be regarded as being in contravention of the Act. Hope that answers your question.
Thank you, Jasmine. The next one. Does the MC or JMB have rights to renovate, upgrade the common property? Does the MC or JMB need to obtain approval at an AGM for such renovations? John?
Thank you, Daphne. Does the MC or JMB have rights to renovate? This is quite a general question. To answer a question, it would depend on the extent of that upgrade. But whether the MC or JMB have that, yes. But where would the funds come from? So the Section 23 and Section 50, which relates to maintenance account, states that the maintenance account can be used to maintain a common property in good condition on a day-to-day basis. Whereas if you look at Section 24 and 51, which relates to the usage of sinking fund account, and this would be, for example, the painting or repainting of the common property and the upgrading and refurbishment of the common property. But I think take note that the upgrading and refurbishment of common property only comes within the purview of the MC, not before the MC comes in existence. Thank you.
Next questions. In respect of the penalty of fine of maximum, the maximum fine of 200 ringgit by the MC, can the MC impose a daily penalty of Rn 200 for each offense, say for an offense where they are running an Airbnb or like a parking offense? Jasmine?
Okay, so the Act itself does not actually specify the frequency of which the fines can be imposed, only that the fines can be imposed if a proprietor is to be found in breach. So if we were to take a literal interpretation of the Act, then technically there's nothing that can prevent the MC from fining a proprietor 200 ringgit for every new day that they catch you breaching the bylaws. So if you breach it every day, then yes, I suppose they can fine you 200 ringgit every day.
Thank you, Jasmine. What is the difference between a normal resolution and a special resolution? John can take this.
So what we call an ordinary resolution for matters that mostly day-to-day, and what it means is it just needs a simple majority. So it can be 51 against 50 and the motion passes. But if it's a special resolution, it will require, as explained earlier, it requires 21 days notice, 3/4 of votes to pass that motion. So coming back to ordinary resolution, that would require 14 days notice for the notice of the general meeting, which would include the agenda and all that.
I think we will take another 2 questions. Is the road surrounding our office complex, which will lead into basement car park, classified as common property? The developer states that it belongs to them and include all car parks on ground level. Maybe Jasmine?
So we will need to look at the strata plans to be certain. But in most developments, the driveways linking all parts of a development, they are usually part of common property because it has to be utilized by all parcel owners.
Thank you, Jasmine. Okay, for our last question, not so much on bylaws, but can a proprietor take any other proprietor to court or the tribunal for leakages from another proprietor's unit? John?
Good question, interesting question, and definitely a very common problem in all strata developments. To answer the question directly, yes, a proprietor can take another proprietor to court or tribunal for leakages, but you have to bear in mind that there is a procedure provided in the SMA and regulations. If you look at regulation 56, it starts off with you notifying the management. Then the management has to come to your unit within 7 days to inspect and determine, firstly, the cause of the leakage and who is responsible for the leakage. Because the leakage may come from common property, which would be the liability of the management, or it can come from another unit above, which would be the liability of the unit above. Then within 5 days, the management must issue what we call Form 28, Certificate of Inspection, which certifies based on the management's inspection, what was the cause and who is responsible to rectify it. And that Form 28 will be issued to the proprietor or the management itself if they are liable for that leakage. So only after you've exhausted this and you don't agree with the finding, there is a regulation, it's called Regulation 64, that if you are not satisfied with the finding, you can make a reference to the COB. But in our opinion, once that is done, you also have the right to initiate either a tribunal action or a civil suit claim against the unit above. Thank you.
Thank you, John and Jasmine, for answering all our questions. I think that will be all the questions that we'll be taking for today. Before we conclude, I have a few announcements to make. But first, let me share my screen. Okay, first, please join us again for our upcoming talks. We have 2 more talks to end the year. The first talk would be on the 24th of November. It will be a talk from our intellectual property team. The topic has not been decided at the moment. And then the last talk for the year would be on the 6th of December from our employment and labor team. Next, please fill out our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Next, do follow and like our social media accounts. Lastly, if you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over a video conference. Please go to our website and fill in the form. The link will also be posted in our chat box. To our guests, thank you for joining us this afternoon. We hope you found today's session informative and useful. Thank you and see you at our next talk.